what employers are doing here is they're using their religious belief to undermine the interests of their own employees. It is ugly, but it is the inevitable nature of RFRA. What happened is that a 5-member majority of the Supreme Court ruled that the Religious Freedom Restoration Act permits the owner of a business to use his religious beliefs to shape health care plans for female employees. And even though those female employees could not have been hired based on religion. Hobby Lobby and Conestoga Woods both argued that it was against their religious beliefs to be complicit in the use of emergency contraception by their female employees. Therefore, they shouldn't have to have the kind of contraception that women use after rape, for example. They shouldn't have to have that in their health plan. They invoked both the First Amendment and they invoked the Religious Freedom Restoration Act. They had no claim under the First Amendment, but they won under RFRA.
RFRA is a law that was passed in 1993, so how did it end up on a collision course with President Obama's Affordable Care Act?
I think that we might not be where we are today without the introduction of the Affordable Care Act. When the Supreme Court, with Justice Roberts in the majority, held that it was constitutional to force people to pay for health insurance who otherwise wouldn't get it, when that happened, there was a huge backlash. And many minds started working very hard on how do you fight the Affordable Care Act because they thought that decision was wrong, but there was nothing they could do about it. The upshot was that they looked for the closest available tool. RFRA was sitting there. But for RFRA, this never would have happened.
What was their argument based on?
Well, essentially, these two litigants have made up the science. They have labeled 4 types of contraception as abortifacients. In fact, they're not abortifacients, according to all medical sources. The emergency contraception that's not permitted is the contraception that women receive after they're raped. This is serious medical care that should be available to women in hospitals in emergency situations without having rigmarole about who pays for it. But what the court said is because they believe they are, those beliefs fly, and that's enough to get you in the door to get the extreme protection that RFRA provides. The problem here is that the RFRA standard is an extreme standard that creates a privileged class. The believer who can claim RFRA can use it as a sword to attack everybody else who doesn't believe the same thing.
What's the broader implication of this? Does this ruling mean that all corporations can now make religious claims?
The threshold issue in the case, the most important question, was whether for-profit, non-religious corporations have free exercise rights. And the 5-member majority led by Justice Alito ruled that, oh yes, apparently they have a soul, if they are closely held. The problem with the reasoning of the opinion is that 90% of our corporations in the United States are closely held. The only corporations that aren't covered by this opinion are the publicly traded corporations. And what's especially troubling is that these 5 members of the court wouldn't even say that publicly traded corporations are not covered. They left that decision to the side. And so basically what you end up with is that every corporation, unless it's on the New York Stock Exchange or some other stock exchange, is in fact a religious actor. And if their owners are religious, they can use their religion to shape their workplace. This case crosses the line by not just protecting the Greens' religious beliefs and practices for themselves. This crosses the line because it permits them to impose their religious beliefs on their employees.